Kansas adopted its own version of the Residential Landlord and Tenant Act, and it's found in Kansas Statutes Chapter 58, Article 25. This gives the state a clear statutory framework for habitability, but Kansas applies it with a balance that leans moderately landlord-friendly compared to coastal states. Under Kansas law, landlords have specific obligations outlined in Section 58.2553. You must comply with all applicable building and housing codes that materially affect health and safety. You're required to make all repairs and do whatever is reasonably necessary to keep the premises in a fit and habitable condition. That means maintaining the structural integrity of the building, keeping plumbing in good working order with hot and cold running water, ensuring electrical systems are safe and up to code, providing adequate heating facilities, maintaining any cooling system that was provided as part of the rental, supplying working smoke detectors, keeping common areas safe and clean, and providing adequate trash receptacles where applicable. Now here's something Kansas landlords should pay attention to. The state deals with weather extremes on both ends. Kansas summers can push well above 100 degrees, and winters bring ice storms, heavy snow, and sub-zero wind chills. If your rental comes with air conditioning, maintaining it through the summer isn't optional. And heating failures during a Kansas ice storm are emergencies that courts expect you to address immediately. Kansas follows a notice and repair process for habitability issues. When a tenant identifies a defect, they must notify the landlord. For conditions that are not emergencies, Kansas law gives the landlord 14 days after receiving written notice to make the repair. If the condition involves a material threat to health or safety, the timeline is shorter, and the landlord is expected to act promptly. If the landlord fails to act within the required timeframe, Kansas tenants have several remedies. Under Section 58-2559, if a landlord's non-compliance is material, meaning it substantially affects health and safety, the tenant can deliver written notice specifying the problem. If the landlord doesn't remedy the situation within 14 days, the tenant can terminate the rental agreement. The tenant can also recover actual damages caused by the landlord's non-compliance. Kansas also allows tenants to pursue rent abatement through the courts. If a court determines that the landlord failed to maintain habitable conditions, it can reduce the rent to reflect the diminished value of the property during the period of non-compliance. One thing that distinguishes Kansas from more tenant-protective states: there is no broad statutory repair and deduct remedy. Tenants cannot simply hire a contractor, make the repair, and subtract the bill from rent. Remedies must go through proper notice procedures or the court system. This gives Kansas landlords more control over who performs repairs and at what cost. Kansas does allow the landlord and tenant to agree in writing that the tenant will handle certain maintenance and repair tasks. Under Section 58-2553, these agreements are permitted as long as they are entered into in good faith, are supported by adequate consideration, are separate from the rental agreement, and do not involve obligations that are primarily the landlord's responsibility under building codes. So there's flexibility in how you structure the maintenance relationship, but you can't use these agreements to dodge core habitability duties. Local codes add another layer in Kansas. Wichita, Kansas City, Topeka, and Lawrence all have their own municipal housing codes with inspection and enforcement mechanisms. Wichita in particular has a rental inspection program that requires properties to meet local standards. Landlords in these cities should familiarize themselves with the local requirements in addition to state law. Kansas has anti-retaliation protections under Section 58-2572. Landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant making a good faith complaint to a governmental agency about code violations, complaining to the landlord about habitability issues, or organizing or joining a tenants association. If a landlord takes adverse action within 6 months of the tenant's protected activity, there is a presumption of retaliation that the landlord must overcome. For the full guide to Kansas habitability laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.